Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Blake. To my left is Judge Sachs. And we are your panel for the 4 cases we're hearing this morning. Thank you for your patience. We heard a 5th case on Zoom before this. And if you're paying attention, you realize that one of our 6 cases from the day is off our list. I want to assure everybody that we have read the brief, so we're familiar with both the underlying facts and the arguments. And I say that because 15 minutes is generally not a great deal of time, so we urge you to cut to the chase to the extent possible. That said, if you feel like you've made your points, there's no shame in sitting down, or as one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day, 2022 P476, Commonwealth versus HENDREN. And we're hearing from the Commonwealth first.
Good morning. May it please the Court, ADA Jacqueline Martinelli for the Commonwealth. A dismissal with prejudice requires either egregious governmental misconduct or a serious threat of prejudice to the defendant, neither of which were present here. Whether the
judge have dismissed it without prejudice, would that be a problem?
Yes, Your Honor. Because in this case, dismissal was improper because there was no threat of prejudice for the defendant to have a fair trial, because what the defendant was trying to challenge were potentially false statements by the affiant, and he already had the information necessary to launch a Frank's challenge if he had wished.
I want to drill down on that argument a little bit, because you seem to be saying, well, he had a good Frank's challenge anyway. He didn't need this additional, make it even stronger Frank's challenge.
So
usually the defendant before us is arguing, oh, they didn't really need this evidence. And our response is, there isn't a dial in the courtroom saying, oh, the Commonwealth has enough evidence, we don't need to go there. Seems like the opposite is true here. They have facially a fairly strong Frank's argument, but it's even stronger if they get this additional information.
So, Your Honor, what I think what's important to know is that there is a balance, because this privilege that has been long withstanding the Commonwealth has a substantial purpose of protecting the informant in cases like this against the defendant's right to challenge.
And how do you deal with the fact that the judge accepted counsel's invitation to restrict access to the information to counsel only? So isn't your argument dependent on assuming the bad faith of counsel?
So no, Your Honor. So I think as I believe what Your Honor is stating, the protective order that was ordered for the defense attorney not to share this information with defendant, while that might be the right procedure, it doesn't mean that we can skip every single procedure that is well established in the Commonwealth before turning over a confidential informant's identity. And all of that was skipped here. And I believe the SJC recently decided, had a similar situation with Commonwealth v. Whitfield. I did submit a 16L a letter to that effect regarding that, the protective order, and still how the proper procedures need to be followed prior to making the determination if we're going to pierce that high veil in this case.
Didn't the Commonwealth waive the sufficiency argument? By that I mean that the argument that there was no properly substantiated Frank's issue here.
No, Your Honor. From the very beginning, from the first time the opposition, the Commonwealth argued in front of the motion judge, the Commonwealth discussed the sufficiency. Additionally, Your Honor, in this type of case where this was a discovery order, we we didn't have many appellate options in terms of having this before a court decided on the merits. So in this case, yes, we lost the discovery motion, the disclosure was ordered. We then filed a motion to reconsider, as well as Boston Police Department filed a motion to reconsider. That was denied. At that time, we filed a petition for relief under Chapter 211, Section 3. That was denied on the papers without hearing, based on not having the extraordinary circumstances present necessary to hear that. So
There's no appeal of the denial.
yes, Your Honor, that is correct. We did not appeal the denial, but still the merits would not have been reached in that instance. It would only be if the single justice had erred in denying it on the papers. And then
Okay,
yes,
but
sir.
let's just go back a step, because at the initial hearing in the Superior Court, counsel for the defendant said, I have all the documentation here. And the judge said, I don't think you need to present it because the Commonwealth isn't challenging that. And then there was either an overt or an implicit acknowledgement by the Commonwealth that it wasn't challenging the strength of the showing, that there was a Franks issue here.
So,
Wasn't that issue waived at that point?
no, Your Honor, and I would submit that during that initial hearing, there was a claim where the judge said, you're not, Commonwealth, challenging that defense counsel's affidavit is false. And the Commonwealth said, no, we're not challenging that. And that was absolutely correct and is still correct, because the defense attorney did not make the substantial preliminary showing because he has no personal knowledge to the affidavit. And I believe it is clear that when the Commonwealth's, when the prosecutor's arguing, he says, even just say for argument, he's met his substantial preliminary burden. We haven't gotten that point yet. So that was not a waiver. That was just saying, as an officer of the court, the defense attorney is not incorrect, but still that's not sufficient because he doesn't have personal knowledge, because he has had no first-hand account of what happened.
So then what should have happened? They file a motion to compel discovery, you don't comply, and the judge dismisses the case. What should have happened?
So what should have happened in this case is, first, the judge should have reviewed the defense's affidavit to see if it was valid. In terms of this case, the defense...
See if it's valid? Is that the standard?
So in order to, under Rule 13A2, an affidavit for a pretrial motion has to be with someone with personal knowledge.
All right, so whether he was competent to...
What's wrong with the affidavit at Record Appendix 23? How is it defective? It says counsel has reviewed the information that shows the car was in the shop from November through the first week of December.
So why this affidavit is inadequate is because the defense attorney, while understanding he's come through information, I believe it was receipts, a police report, and an affidavit from someone, he did not attach the documentary evidence. And
He was in court, or it was, I can't remember if it was he or she, but the person, the defense counsel was in court and said, I got all the documentation here. Do you want to see it? And the judge says, not necessary, because the Commonwealth isn't challenging this. And whether it was you or someone else, they said, that's right.
so again, I think that the Commonwealth is seeing this differently because at that point, one, the defense attorney has no personal knowledge, and that is why not only did the trial prosecutor state, yes, defense affidavit, we're not saying is false.
Why do you say he has no personal knowledge? He says in his affidavit that he's reviewed the documentation that shows, what more personal knowledge do you want? Does somebody have to have been at the body shop 24 hours a day to attest that the car didn't go off the premises?
Well, yes, or the defendant could have, under oath, said that my car was in the shop from November 5th to December 6th of 2018. But defense attorney is not equipped of someone now, after the fact, reviewing receipts. He has no personal knowledge of when this vehicle was actually in the shop. And if he had maybe the body shop owner submit an affidavit or the defendant himself, that would have been able to meet that standard.
Keeper of the records affidavit.
In what context?
As to any of the things he says he has, the police reports, the insurance estimates, the receipts of service. Paragraph 5 of his affidavit, he says he has those documents. What if those contained a keeper of the record certification that they were true and accurate copies?
But that would not make a difference because the keeper of the record still doesn't have the personal knowledge to say that
That's exactly what the keeper of the records is, right? He's attesting they're true and accurate business records.
But it could be true and accurate that there's a receipt that this car was in the shop, but he still doesn't have personal knowledge if that car was actually in the shop the entire time.
Back to Judge Milkey's point, someone has to sit next to the car 24/7, 365. It's the only way you can have personal knowledge.
I think the two people in this case with personal knowledge would be either the defendant or the auto body shop.
The defendant didn't sit next to the car in the body shop. Your argument is circular.
But he would know if his car was in the shop. And again, with the standard that this...
No, let's take your argument. Maybe somebody broke into the shop and took the car out joyriding.
Understanding that we might not be able to have every scenario under personal knowledge. However, it is clear, and I would point, Your Honor, to Commonwealth v. Duzanis, where it says, under oath, the defendant submitted an affidavit. Every single case that I have come to know while preparing for this argument has where the defendants have submitted this affidavit to challenge Frank's Amaral hearing. And especially not even including the receipts, the documentary evidence, is just a defense saying, hey, I have this information as an officer of the court, but now they're going to put a confidential informant's identity at risk, put their safety at risk, for no one having any personal knowledge had submitted an affidavit.
Your argument might be stronger if the transcript revealed that counsel in Superior Court said, Your Honor, we're not saying the attorney is lying in the affidavit, we're just saying this is insufficient because it lacks the necessary personal knowledge. I don't see any statement along those lines in the transcript.
The statement, in fact, was, the judge says, I don't think the ADA is arguing in any way that the affidavit's false. I think he's arguing that even if it's true, you, meaning the defendant, still have enough evidence to present the motion, right? And the ADA says that's right. That's what the Commonwealth is arguing. So maybe we could proceed on the assumption that this issue of personal knowledge is not in the case. And you could address the question that Justice Milkey started with, which is if they've got two incidents where there seems to be a very clear conflict between the affiant's statement about the car and the records from the shop, you're saying that they're not the defense isn't entitled to discover evidence of a third conflict and that they have to just go with the two they have?
So, Your Honor, again, this is a balancing of the defendant's right to confront an affiant.
Would you concede then that if the defendant had proven that that those two on those two occasions, for those two controlled buys, the car actually was in the shop, so the affiant's statement was false, would you concede then that the judge should have allowed stricken those and invalidated the entire affidavit?
No, Your Honor, because the judge made a clear error of law by not following the mandated procedure that has well been recognized in the Commonwealth, and that is, first, if the defendant had made, let's just say, for argument, the affidavit was sufficient. It wasn't proper to then disclose under a protective order the defendant, the CI's, the date and time of the third buy to effectively identify the defendant. What the judge should have done is determine if the defendant had made a substantial showing to warrant an Amaral hearing, an in-camera hearing, which was clearly not done in this case. And during that Amaral hearing...
Okay, what would have happened during that Amaral?
So in the Amaral hearing, and I would just want to note that the CI itself in this case did not view the vehicle. Every single time the vehicle is mentioned, it's the affiant or a member of the Boston Police Department. So during this Amaral hearing, the judge would have had the opportunity to confront the affiant and determine if defendant has made that substantial preliminary showing that this affiant not only contained either false, knowingly and intentionally statements, or with a reckless disregard to warrant and be entitled to a Franks hearing. So we didn't even get there. We're all the way here where we still haven't had Amaral, we haven't had Franks, and if we got to Franks, still, even if, let's just say, these statements are false, the car was in the shop, we still don't even know if we would have had probable cause to continue with this case regardless. So this is...
The judge have had discretion, if he found that those statements by the officer were false, to discredit the entire affidavit?
Not at this point. Under Massachusetts law, no. At this point, if taking out those...
At any point, would the judge have that discretion?
I believe, how it is at this point is if the false statements were out, let's just say, and there was still probable cause in the search warrant, then the case could still move forward.
I'm asking if the judge has discretion to discredit the entire affidavit, which would obviously invalidate would require suppression of whatever was found as...
No, it's only the false statements.
The judge cannot discredit the rest of the affiant's statements if the judge just has to pick out the two that are false about the vehicle and then has to look at everything else?
Yes, that's what's...
You're talking about at the Franks hearing?
After the
itself?
Franks hearing, if we've met that burden where there are intentional knowing misrepresentations or that it's a reckless disregard, at that point, if you look at the probable cause with those statements out, and if there's still probable cause in the search warrant, then the case proceeds. And that's under Franks v. Delaware.
So what should the judge have done in response to the defendant's motion to compel?
What the judge should have done is again, we have been saying, I think what's really important to note about this dismissal with prejudice is that throughout the entire part of this case, from the first time we argued to the end, we put the judge on notice that that this discovery order was riddled with legal error and that we were...
The clock is ticking. Can you answer my question?
Yeah, so what the judge should have done is, one, dismissal was not appropriate. He should have followed the proper mandated procedure in determining if disclosure was necessary in this case and if the defendant has made his substantial preliminary showing. And what would have happened in the Franks hearing, we would have had the opportunity to decide, but we just hadn't got there, so this is all speculation until we had followed that proper procedure.
You have any published case that rules in the Commonwealth's favor on disclosure issues based on the risk of disclosing the identity of a CI where the information was restricted to counsel only?
I believe Whitfield was a similar issue. I know that we didn't get to a Franks hearing in that case, but it was all about the privilege and disclosing under a protective order. So I do believe that would be the case that was recently decided by the SJC. If there are no further questions, I would rest on the Commonwealth's brief. Thank you.
Thank you, counsel. We'll hear from the defendant.
Good morning. May it please the court. My name is Anne Rusev, and I represent Andrew Hendren. If I could pick up right where the Commonwealth left off, there was no protective order in Whitfield. I think Whitfield is very instructive as a foil in this case. It was decided after the briefs were filed in May. But it's obviously the SJC's most recent pronouncement on a similar issue where they found that disclosure of some information was tantamount to disclosure of the entire identity of the CI. There are 6 key factors that distinguish Whitfield from our facts. And essentially everything that Whitfield lacks, this case has. There was no protective order in Whitfield. Defense counsel in Whitfield had proposed one, and the Commonwealth essentially never took him up on the offer. So in Whitfield, all of the information that was ordered there would have gone straight to the defendant. Secondly, in Whitfield, it was an astronomical amount of information that was ordered. It was the complete history of this informant with any law enforcement agency, not even just the Boston Police, but any law enforcement agency. Third, there was no allegation in Whitfield of a case-specific reason why this was necessary. In Whitfield, there was sort of an argument that, well, there's not really enough in the affidavit to allow us to test veracity, so we need more information to do a proper investigation. That, of course, is not enough under AMRAL to cast a reasonable doubt on material representations. Fourth, there was no basis to believe that disclosure in Whitfield would go to a trial issue. The CI was relevant to the motion to suppress only. Here we have a very specific, explicit argument that this is relevant to a trial defense attacking the credibility of a key prosecution witness. Also in Whitfield, there was a concession that disclosure of the identity would result in a danger to the CI, and there's no such concession here. I would also point out In Whitfield, there was no claim of specific untruthfulness in the affidavit, just sort of a concern about the possibility of untruthfulness. Obviously, here we have a very fulsome showing. I think probably the best showing I could find in any reported case, attacking the credibility of the affiant. And I think another thing that the Commonwealth noted was that the CI never described the Honda. That is correct. What the CI described was a white construction van. The CI never described a Honda. So this is an attack not on the credibility of the CI, as you often see.
But on the officer.
On the officer.
May I ask, in page 19, footnote 9 of your brief, you say, at a Franks hearing, the judge would have the discretion to discredit all of the affiant's representations based on the demonstrable falsehoods. Do you have a case that says that? Because the Commonwealth is contesting it.
I don't. I'd be happy to look for one and file a 16L. I frankly think it's self-evident that at an evidentiary hearing, the judge has discretion to credit or discredit anything.
Well, yes, at an evidentiary hearing where everything has gone over, but it's still in the affidavit, and the Commonwealth says, well, the procedure is the judge can strike anything that is found to be false or made with reckless disregard for the truth, and then look at the rest to see if it's sufficient for probable cause. What's your response to that? Does the judge have discretion to discredit the whole affidavit?
Yes. I think upon a showing that there are two material misrepresentations in a sworn statement by an investigating officer, a judge could certainly decide that even if there's not specific proof that a third statement is false, that they could discredit that statement as well based on the demonstrable falsehoods. I think the other issue...
And what follows from that? I mean, there's still a control of the fourth controlled by.
Yes. So
why would the evidence have to be suppressed other than search of this person?
So I think there's two problems with that. One is that we don't know if excising is an appropriate remedy under Article 14. Certainly, if we are in federal court, you can excise false statements and you examine the remainder.
You point to the Ramirez case
Yes.
in that same footnote that says Article 14 may require, but the
Yes.
SJC hasn't gone there.
That's
You
correct.
haven't really made an argument in your brief that there's a reason to go there, although I understand you might like it.
Yes, certainly.
So is that really the answer? I guess I would say, if you have a case that supports the idea that the entire affidavit can be discredited based on some blatant misrepresentations, that would be helpful.
I will certainly find one and submit a 16L. I think under Ramirez, it is an open question. We don't know the answer about whether excising is consistent with Article 14, but I think certainly Article 14 jurisprudence up to this point suggests that it would not be. It continue to adhere to Aguilar-Spinelli. We take a more protective role towards defendants' rights in the search warrant context than the federal system does, and many other states do as well. So I think this court would have every reason to expect that the answer about whether excising is sufficient under Article 14, that the answer would be no. But if I could get back to your point, let's assume we're in the federal system and you could just excise. I think the reason it doesn't work, you can't do a purely legal analysis like that here because the credibility problem infects the entire affidavit. It's very different than sort of the prototypical example where you have, let's say, a search warrant where a confidential informant makes some contributions, it's determined later that informant doesn't meet Aguilar-Spinelli, so an appellate court could strike those contributions and examine the remainder. Where you have a credibility problem that infects the entire affidavit, you need a fact-finding judge to make that determination, not an appellate court. So I think there's factual issues that need to be resolved, and so excising doesn't work. But even, let's say...
Does that mean you would not have objected to Emerald Frank's hearing?
Prior to disclosure?
Yes.
I can't say what trial counsel would have done. I think certainly I would conceive of this case as a pre-Amaral discovery motion. That's the posture. A judge certainly has the authority under Dusanis and other cases to order discovery in anticipation of a Franks hearing or to aid in the judge's own determination of whether a Franks hearing is even necessary.
Well, then to go back to, I believe, Justice Milkey's first question to the Commonwealth, could the judge have proceeded with an Emerald Franks hearing with the information that he had, and then depending on how it came out, a second round of hearings as to this third controlled by?
I think that's possible. I think that the Amaral-Franks framework lends itself to flexibility. We know under Amaral, attorneys don't even need to be present. The DA may not be present.
One shot at it.
Yes. I think that with the consent of the parties, a judge could structure a hearing in an incremental fashion if that's what made sense. And this is the type of thing that trial judges and motion judges are perfectly equipped to do. We afford them great deference in ordering discovery, crafting sanctions.
Understood, but following up on that,
Yes.
why wouldn't that have been a preferable procedure here?
Well, the Commonwealth also didn't ask for an Amaral hearing at that time. That was an argument that was not made at the initial hearing. It was suggested later that it would have been appropriate in a late filed motion to reconsider. So the idea of moving straight to Amaral was never presented to the motion judge. I think potentially it could have been, it could have worked. I do think though, part of the problem with this idea that we can just skip straight to Franks is that the defendant not only has the right to file a motion that meets sort of the minimum threshold, but to gather all relevant, all available evidence to actually carry the burden at that showing. Like in Franks, once you get to the hearing, the defendant has the burden to prove perjury. That is a notoriously difficult standard to meet. So he's entitled to explore all possible credibility issues to bring to bear at that hearing. And I think this court has already mentioned, there's not a dial where we tick over and say, this is sufficient, you don't need more.
Can we quote you on that in future arguments? I just want to drill down on one factual point. A basic premise of your argument throughout has been that for the third controlled buy, you need to know exactly what time it went down. Is that actually true when the key issue isn't what time it went down, it's did it go down before or after the car allegedly came out of the shop? And weren't there ways the judge could have looked into that while being able to avoid disclosure of the exact time of the controlled buy?
Absolutely. I think that's true. And I think had the Commonwealth made the point that Your Honor just made, the judge could have said, okay, counsel, you know what? I want to see those documents ex parte. I want to know what time this car left the lot. And then Commonwealth, you can submit the documents to me and I can determine whether this buy is within or without the threshold that we're talking about. So I think the judge does have flexibility to do something like that if given the opportunity, but that burden would be on the Commonwealth to try to narrow the inquiry as much as possible.
Defense counsel proposed something like that?
I don't believe so. I think defense counsel just said, I have the documents available if it would assist the court, and as this court is very familiar with the transcripts and noticed that the judge made the statement about, I don't think that the Commonwealth's actually challenging the credibility of the affidavit, and the DA says no, we're not. So the judge never got to that point of examining the documents that were offered.
I know that you're appellate counsel and you weren't counsel below, but do you see these types of orders with any degree of frequency that defense counsel can't disclose something to their client?
Oh, frequently, in many different contexts.
So there's nothing improper about that order from the defense perspective, at least prima facie?
No, I mean, I think what defense counsel said at the time was, I'm not going to love this if you order a protective order. I want to be able to share this information. This is my role as counsel. But if the court finds it necessary, I will agree to that. So I think the preference of defense counsel is always to have as full communication as possible with the defendant, but obviously in more sensitive situations, the important thing is to get the information to mount a full defense. And in this situation and in, let's say Rule 17 information, where a court is ordering very sensitive information that is impounded and counsel needs to do successive Dwyer motions without revealing the contents of the records that have already come into the client, this is something that courts and defense counsel deal with routinely in many different contexts.
You have put together a waiver argument in terms of what the Commonwealth has waived by not arguing certain things at certain times. As you know, typically when you're on the other side of the podium, it's hard to waive an issue in a criminal case. And obviously the Commonwealth is situated somewhat differently. than a defendant, but aren't there important issues here that potentially cut against waiver? Your client was found with a very large amount of crack cocaine, I think it was crack cocaine, and the judge dismissed a live case based on this. Why shouldn't we be reasonably lenient on the waiver issues under these circumstances?
Well, I think it's certainly true that it can be a difficult burden to show waiver, especially against a defendant because we have the substantial risk analysis in Massachusetts. I think it's different when it's the Commonwealth who has waived an issue, particularly where there's issues that weren't before the motion judge, so the motion judge never had the opportunity to pass on them at all. But I think even...
Well, no, but the judge did the second time around when the Commonwealth came back and said, okay, we want you to reconsider.
Yes.
Now, arguably it was waived at that point, but
Yes.
arguably, I mean, presumably the judge had at least some discretion to say, yeah, you didn't raise it, but given the importance of these issues, I'm going to do it now.
Yes, and I think that is true with the exception of the third issue I raised in the brief, where this idea that because there weren't drugs in the car, the third buy is totally irrelevant. That was never waived in any, that was never raised in any form before the motion judge, either initially or in a motion to reconsider. So I think that is waived entirely. I think certainly a judge has the discretion to entertain a late filed motion to reconsider, certainly. There's no basis to believe that that is actually what happened here because the judge never reached the merits of the motion to reconsider. He just wrote a simple denial in the margin. And without some new findings or new rulings.
The judge may have reached the merits, we just don't know.
We don't know, yes, yes. And it's not apparent from his findings whether he denied the motion to reconsider or entertained the motion to reconsider and decided upon reflection to adhere to his original ruling. But if I could get to the rest of the question, I think even if you put all the waiver issues to the side, and I did raise many of them, put them all to the side, the remaining issue is whether the judge abused his discretion in dismissing this case when the Commonwealth deliberately refused to comply with a court order aimed at uncovering evidence of police misconduct, specifically perjury, which is a crime, so perhaps one of the most important kinds and one of the most serious kinds of police misconduct. The answer is no. There's no abuse of discretion, and the answer comes directly from Washington W. In both cases, the Commonwealth repeatedly, deliberately failed to comply with a court order. That defiance was found to be egregious prosecutorial misconduct, and dismissal with prejudice was necessary to cure this prejudice to the defendant's rights. In Washington W., the SJC reviewed for an abuse of discretion and found none. And
this is dependent on the validity of the discovery order, the disclosure order.
Well,
I mean, if the disclosure order was valid, we could conclude, as you're arguing, we could conclude that the dismissal was warranted. But if the disclosure order was not valid or should not have been entered at the stage that it was, then whether Washington W says what it says is not really.
That's true. If you skip over the waiver issues and you go straight to that. But I think in addition to being waived, the argument fails on its merits. It's the Commonwealth's burden to show that disclosure of this information just to defense counsel would result in the identity being disclosed. They have failed to carry that burden because that has a false premise at the start, and that false premise is that defense counsel, an officer of the court, would violate his oath and violate the protective order. That premise is as insulting as it is meritless. Since they can't meet that burden to show that the privilege is properly invoked, we're in the land of Rule 14. The standard is relevance, and the relevant standard is very easily met by this detailed affidavit and offer of proof. And I see I'm over
Counsel,
time.
you're going to have to leave it there.
Yes.
Thank you both very much.
Thank you so much.
The case is submitted. Our next case is 2022 P1032, OBARA versus GHOREISHI. I apologize if I've mispronounced any names, and we'll need just a minute to reconfigure. Just to clarify, I assume this is the subject of the conversation. When you're arguing, sir, unless you're directly next to the podium, the cameras will not pick you up, which is why, exactly. So, counsel.
Good morning, Your Honors. May it please the Court, James Reedy on behalf of KAYOKO OBARA. When a matter is remanded from this court to the probate court, when a divorce matter is remanded, for a reconsideration of the mandatory factors under General Law, Chapter 208, Section 34, and potentially for a redistribution or revaluation of marital property in accordance with that reconsideration of the mandatory factors. The consideration of those two issues occurs at two different time periods.
Well, I want to stop you. I know you're going to tell us about the prongs of Johnson, but I have some fundamental questions about.
Sure.
Your brief refers really only to the judge's findings. There's no cites to the trial transcript. So I'm struggling a little bit with that because you make some broad statements about the value of the real estate being uncontested. Certainly there's a sale of one property and that number is what it is, but you didn't provide us with financial statements. We requested those from the probate court. I don't have any transcript cites, so how do you want us to draw the conclusion that because the judge didn't credit the information about the value of the real estate, you ask us to draw an inference that it was uncontroverted? How do we get there? I can't find it in your brief.
So, two reasons. Well, first off, I would suggest that the reason that the transcript wasn't cited was there was no really challenge, at least as it occurred to the court's consideration of the value. So I also believe that the court, if I'm correct, referenced within its findings what each party testified to relative to the values.
I've done a word search in the transcripts. I've read the transcripts. I can't find any questions about the value of the real estate except for the property that was sold for $719,000.
So I'd be happy to provide a 16. I believe the transcripts.
This was your burden to come here today.
Understood. There was not.
They used the financial statement values. People testified at the trial.
People testified at the trial. There was nothing within the financial statement values, as far as I was made aware.
The financial statements that we just got have values, so now you have me completely confused. I found no evidence of questions about value at the trial.
Even if there was an issue with the difference, even if the court were to accept the values as found by the trial court within its findings, there is still a distinct difference between one property which was sold for $329,000 above the value provided by the trial court, which provided.
Do you want us to find that the judge's conclusion as to the value and the fact that he didn't use 2020 values is clearly erroneous?
I do. And I think that there is.
Here's the evidence of that.
But remember, what I asked for within the request for relief was a remand back to the trial court for this reason. It is clear the trial court valued it based on the 2023 valuations. The trial court was required to make a determination of the present value.
2023 or 2020?
Excuse me, 2013. So the court valued the property based on the valuations provided by the original findings of fact, which was 2013. On a remand, the court is required not only to make an assessment, it's required to make not only an assessment of the present valuation of the property, which would have been at the time of the division, which would have been 2020, but the court was also required to make a determination of how those properties appreciated or depreciated, and who is responsible for that. He didn't do that. So the request for relief.
But he says, I didn't have competent evidence in footnote 3, right, at record 89. He says, I don't credit the evidence as to value. So if he has no other value other than what he had in 2013, and you all didn't put in that evidence.
So I would suggest that the court did have evidence that there was a difference in value, that at least one of the properties had a difference in value.
As to the 719.
Given the fact that it sold for $719,000, and I believe the court valued it at $385, or it was about a $329,000 difference. So the court, I don't think can simply sort of abandon its responsibilities to value it as at the date of division. And the court certainly also has a responsibility, and I understand that the parties, and I was not trial counsel, I understand that the record was rather sparse on that particular issue. So it's not simply that I'm asking this court to say this is what you should value at and this is what the division should be. I'm saying that the trial court failed to not only provide the present day valuation of 2020, but also failed to make a determination of the appreciation or depreciation who was responsible for that.
Back to my initial question, you're asking for a do-over, really to give you the opportunity to put on evidence that you didn't put on at this trial.
Or I'm asking for the court to do what it was supposed to have done regardless of whatever failings may have occurred from trial below.
What does a trial judge do when they don't have evidence?
Within the probate court, much as the probate court can appoint a guardian ad litem, I'm not suggesting that's here, I'm just using it as an analogy. The court could certainly appoint an independent master to make a determination relative to the property values.
Oh, counsel, this is not a Rule 53 case. I assume you know that I was a prior probate and family court judge. If a judge doesn't get trial evidence, there's nothing they can rule on.
In this case, there was certainly evidence, at least when occurred for the 719 value, that valuation should have been considered, and husband shouldn't have been given a $329,000 windfall.
So let's assume I agree with you on the 719.
Understood.
Does the judge ignore the other 4 properties because he didn't have competent evidence, or does he use what the parties reflected on their financial statements that you say was uncontested or stipulated to?
He certainly could use what was on the parties' financial statements, but I think that those financial statements don't necessarily come down to the factual findings of whether there was the responsibility for appreciation or depreciation of the property. For example, let's take the one that was $719,000. If that property appreciated because husband put in a significant amount of money into that property, then obviously that's something that the court should have considered. And I know the record was sparse here on both parties as relative to whether that property, as to why that property was worth so much more than it was. And that's what I'm suggesting the court should have done here.
So I did a little bit of math, so don't hold me to it because we're lawyers, not mathematicians.
I made a mistake in the brief on this, so I'm not going to hold you to that either.
I understand that the first judge said equitable, not equal. The second judge said equal.
Correct.
So if I use the 2013 numbers, I'm sorry, if I use the 2020 numbers, you say it's roughly a 70-30 division in favor of the husband.
So, yeah, I redid the numbers on that before because I had, much like yourself, I realized that math is not my strong suit. And I believe that if you take the total.
What did you come up with for the total assets?
For the total assets for the properties relative in 2020? All right, let's see if my math is correct. I had
under 3.8 million?
3.3788600.
That's exactly what I have.
Correct.
All right, so that's roughly a 70-30. If we do what you say and we divide the proceeds of the 719 above and beyond the 390, let's say hypothetically we gave your client that money, or we told the judge to give your client that money, what does the division come out to be?
Math on the fly. So what I'd suggest is, if you take the 377, the 3.7 and change, if that's the total value of the property, each party should have received about just shy of 1.9 million, if you divide it in half, which is what the court did the second time around. So with using the 2020 valuations, the actual division would be 710,000 and change. And then taking into consideration the amount provided to the wife, which was a $431,000 cash payment and change, which leaves the wife at $279,000 shortfall. If
50/50 as of 2020 values.
Correct, but if the court is considering, well, we're taking the we're just taking the 719, we're leaving the other values as is, and you're taking the 719 with the $329,000 difference, I'd suggest on a 50-50 split, that 50-50 split would be, approximately $165,000. If that makes sense, math-wise.
You make a separate argument that the judge should have considered the impact on the wife's earning capacity of transferring the dentist office condominium to the husband.
Yes.
Did you make that argument to the judge on remand? And if so, where can we find that in the record?
That was not made. I don't believe that was made below. And I'm sort of left with that situation of where it is now. It was, the court essentially when it remanded said, based on the previous order of the appeals court, that there wasn't a consideration of the modifications to the dental office for husband, simply followed that sort of logic, but without a consideration of where it went to the wife. I do think there was evidence presented to that, but part of the reason why I still think it was incumbent on the court to consider those factors. They weren't discretionary factors, they're mandatory factors to be considered by the trial court. So regardless of whether there was the argument below, I think the trial court was required to make that consideration, and it did not do so here. And I will certainly admit that trial counsel below didn't make a strong argument on that.
Your argument is it was not waived because the judge had an obligation to deal with that.
Correct.
Anyway.
Correct. The waiver doesn't apply because the trial court still has to apply the appropriate standard. And I don't believe this court, at least in other instances, when it considers standard review, considers the standard whether that was an error of law or not. And I'd suggest not considering it to the extent that admittedly the court can find from a lack of consideration within the findings, which are relatively sparse on the issue, that it wasn't considered, understanding that limitation.
Well, really not trying to give you a hard time, but I'm struggling here because if you read the judge's findings and he assigns the building that the dental practice is to former husband, he then, with that knowledge, makes findings about each party's ability to earn income and also under Section 34, their opportunity to acquire future assets and income. So I read that implicitly as dealing with what may or may not be a waived issue, the second issue in your brief.
So, understood. But I think one of the things that the court didn't consider, again, at least explicitly, and whether the court finds that implicitly is obviously up to the court, and it wasn't necessarily argued by trial counsel, wasn't argued by trial counsel below, is the findings of fact that the court originally adopted. So the second court obviously adopted the findings of fact of the trial court.
As amended by the second set of findings.
Absolutely. And one of the things that the trial court didn't address in that second finding was husband's ability to earn income outside of that particular dental practice, which was substantial, given the fact that husband would, on occasion, fly to Dubai, provide practice dentistry there, and return with.
I didn't see any cites for that in the brief. That had occurred recently.
I believe that was cited to the record appendix, which was based on the first finding of, based on the original finding of the trial court, which was then adopted by the
2013.
But the 2013 findings.
We have no evidence as to whether that's continuing.
No, absolutely not. But I'd suggest, and this is why I discussed, there's two different. The findings are considered at two different times. The ability to earn income, and again, this is a little unusual because we're dealing with a 7-year delay between the original trial and the remand. When the findings are made relative to the mandatory factors of Section 34, those are made as of the date of the divorce.
Well, look at page 91 of the record. When he talks about your client's earnings in the dental practice at the time of trial, and that it's roughly now $1,400 a week less. So he did do a then and now.
And quite frankly, I actually don't think that was
And-
proper. It's not raised as a separate issue because, but it's quite clear from the case law of this court that the factors are to be considered at the time of the divorce because that's when the parties separate. And that's when the division of the property as far as percentage goes and why it's divided is based on the condition of the marriage. That marriage has ended. I'd suggest it's inappropriate for the court to consider in the meantime what has happened when the date of consideration is supposed to be at the time of the divorce because that's when they split. Whereas valuation is something different. That the valuation of the property is supposed to be considered at the time of division because of many reasons that a property could depreciate or appreciate either by the acts of the parties or by simply the natural occurrence of time, whether that's stocks, bonds, what have you, or real estate. Seeing if there are no further questions?
Hearing none.
Thank you.
You very much. Sir, before you begin, if you could move over as
Is there any
close
chance
to the
that you
podium
can
as
move
we can.
closer? Because you're out of camera view. I think this is the closest he can get because of it. Okay.
Perfect, thank you.
Now, do you hear me okay?
Yes.
Okay. As I mentioned, I'm a process, so I have a note and I never able to talk.
If you could
much.
speak up a little, sir.
Okay. I have two issues that I have mentioned. I'm going to read it to you. Use of real estate value of marital assets at the time of.
Sir, if you could speak up a little, the volume is hard to hear.
We move the microphone any closer.
How about now?
Want it closer?
Okay. Do you hear me okay? The judge found that the division dividing the real estate assets is both equitable towards the values stipulated at the time of the first.
Yeah, that's better. Go ahead and speak.
At the time of first trial. In January 2013, rather than values mentioned in the remand trial in January 2020. He had good reasons to make this decision. The judge took this action because of the length of the time between the first and second trials, and because of the lack of credible evidence of the current values of the various real estate properties. Of the five real estate properties from the time of the divorce judgment, the wife had two and the husband had two. The only property dispute was the office property. There was significant delay after the appeals court's decision in March 2016 and the conduct of the remand trial. The wife had substantial ability to conduct discovery if she wished to raise the current values as a significant issue. The wife maintained control of the office property from the time of the first judgment until 1 year after the remand judgment in August 2021. The husband paid the wife the amount ordered by the judge to equalize the division. No basis for wife to claim she is unable to practice dentistry at another location. The judge found that the wife had the ability to continue to earn income from the practice of dentistry. There is no evidence that the findings was erroneous. The decision allowed the husband to retain and use the office was a division of office property only and did not involve the division of the dental practice. The wife had the physical and professional ability to work at another location or as part of another dental practice. She does not have any physical disability. The wife claims that the husband can travel to Dubai to practice, but ignores that he had last done so 25 years ago. The award of office to the husband permits him to overcome his disability and utilizes his talent to save humankind.
Did you sell that property for $719,000?
That property was incorrectly incorporated into a marital asset.
Did it sell?
It was sold not by me,
Was it for $719,000?
by the owner.
Thank you.
Sir, we have no further questions, so if you're done,
I'm done.
you can submit the case. Thank you both very much. The case is submitted. The fourth case is the one that is off our list. Our next case is 2022 P1144, Ferrie versus Mass Department of Corrections. Counsel.
Good morning. May it please the court, I'm Susie Harold and I represent the appellant Kate Ferrie. Ms. Ferrie is here today to appeal the order and dismissal of a retaliation lawsuit in the Superior Court based on first reporting sexual harassment, but then filing a lawsuit at the MCAD and then to the Superior Court on the basis of only retaliation.
So is it retaliation for 2014 report of sexual harassment?
So it starts in 2014 with reporting sexual harassment, but then she reports retaliation because of reporting sexual harassment.
I just want to pause you in time. So when she reports the 2014 event, as I understand it, he is suspended and transferred out.
Correct.
Right? She doesn't have issue, at least as I read your brief, with how the department responded in that isolated incident, right?
Correct. She has not advanced a cause of action for sexual harassment.
And then she alleges that all kinds of things were said, or there were words on photographs of her that were circulated, do I understand that we don't have any physical evidence of the photographs, and neither did the judge below?
That's correct. We have her testimony, but the documents were not taken with her.
And so that behavior started when?
After this captain that she reported was transferred to another facility.
Around 2014, around the same time?
Correct. And it continues until her retaliatory termination in 2019. But before the lower court were a series of events where she had reported retaliation, first to her captain and then to the MCAD. And those are the two protected activities that we're asking this court to focus on and ultimately remand to the lower court because the summary judgment decision kind of dismissed these points where she's reporting an adverse action. She's engaging in protected activity. The lower court didn't consider those actions. It's specifically considered reporting the sexual harassment, which is really not what her case is about. She doesn't have a cause of action for sexual harassment. She has a cause of action for retaliation.
Can I just get clear on what she's asserting she was retaliated against for doing? And it's the reporting of the sexual harassment.
That's correct.
Okay. I saw an argument in your brief that perhaps she was retaliated against also for her MCAD filing.
Correct.
But I didn't see whether that argument had been raised below anywhere. Do you know
It had. I mean, the lower court record discusses retaliation for reporting sexual harassment, but then further retaliation for filing at the MCAD.
Where is that in the record?
In the record?
Yes.
If you'll bear with me a moment.
Some of your record sites don't line up.
My apologies.
Yeah.
Is there something specific I could address here?
You need to address Judge Sachs's question, but I will tell you that I found more than 2 handfuls of record sites that didn't line up with the record.
I think the problem came when you added the tables of contents.
My apologies. And your clerk was very kind to me with my filing issues. So if you turn to page 21 of my brief, she specifies examples of retaliation prior to her termination. And there are a handful of issues of retaliation that are in the lower court record that happen in the 11-plus months after her filing of the MCAD charge.
I see those instances of retaliation, but my question is, is she claiming she was retaliated against for doing? And I thought the only issue was for reporting the sexual harassment. I saw a reference in your brief to she was also retaliated against for filing at the MCAD. And my question is, where was that issue raised below? Where did the judge address it? I didn't see it.
It was raised in her summary judgment argument. In her opposition to the Commonwealth's motion for summary judgment, she points out that there's protected activity that goes on for a period of time. And those things include not only reporting the sexual harassment, but reporting it to her captain and then furthermore bringing it to the MCAD. And then in the 11 months between the MCAD filing and her termination, there's a handful of events that she's considered to be retaliatory. So, it's in the lower court record summary judgment.
You don't know where, which volume?
I don't. If you give me a moment, I can circle back to your question.
Well, we can,
Look for that.
yeah, we can look for
Oh,
the memo.
pardon me. It's mentioned between the appellate court records pages 174 to 178.
Is that volume 1 or 2?
I believe it's volume 2.
So,
Pardon me, and then again, pages 201 to 203.
I don't have a record that has those pages. Volume 2 goes up to page 114.
Oh, that's very interesting to me.
That's why I'm really confused right now. Maybe my colleagues have the right one. And volume 1 only goes to page 107, so the sites that you're giving me, I don't have. I'm happy for it to be my mistake, but
Well,
Are you citing to the supplemental appendix?
No, Your Honor. My brief says the appellate record page is 201 to 203.
And that's exactly the problem I had. There is no appellate record 201 to 203.
I think we may be able to find what pages those roughly correspond to because the pages were renumbered when the record appendix was divided into 2 volumes, I think.
I see. Do you want me to refile it?
If we do, we'll issue an order, I think. I'm not sure whether we'll need that.
Okay.
But getting to your instances of retaliation, one of the chief ones that you rely upon is the plaintiff's complaint to Captain Lafort, I believe it was, saying something like, I can't take this retaliation.
Correct.
Why is it a reasonable inference that Captain Lafort even knew what she was talking about? Retaliation for what? What did the sergeant who had assigned her to transport this unruly or subdue this unruly prisoner know about any prior conduct she'd engaged in, protected conduct? How is just saying, I can't take this retaliation enough to put DOC management on notice?
So, first of all, her interrogatory responses indicate that she reported all of the conduct to this captain and reported instances of, having to hear that the relationship was consensual after the fact that he had been terminated. So when she's stating, I said to this captain, I had to continue to hear that the relationship was consensual, certainly I would represent to this court that that's enough that this captain was aware that...
Is that a reasonable interpretation of her interrogatory answer? I'm looking at volume 1 of the record appendix at page 18, and she recounts for several sentences the incident with the combative inmate, and she contacts Sergeant Lee, and he says, take it up with the union, and hangs up. I then went to Captain Lafort and told him what happened and that I couldn't deal with the retaliation anymore. Is it reasonable, even drawing inferences most favorable to the plaintiff, is it reasonable to construe that as her having told Captain Lafort about all of the cold shoulder and the photographs and everything that had occurred before that day? Yes,
I do think that's a reasonable inference to make, because she's clearly stating, I told him what happened and that I couldn't deal with the retaliation anymore. She then goes on to talk about whether the relationship was consensual and the transfer of FERRIE, and I also think it's reasonable to infer that a captain that she reported to would be aware of a transfer of another captain on the basis of her reporting sexual harassment. But if you're looking at just the record in her interrogatories, yes, I absolutely think it's reasonable to interpret knowledge because that's exactly what she stated.
So at footnote 5 of his decision, the Superior Court judge said that he accepts in your client's favor that the ostracization began immediately after her harassment report, but she identifies no particular dates or a range of weeks or months when any retaliatory incidents occurred, nor does she identify any of the individuals involved. Is it because we're here on summary judgment, so is it your view that that is a disputed issue of material fact?
Yes, it is. She specifically says in her interrogatories about when she reported to Captain Lafort that this happened every shift. So every shift she worked, there's records of the shifts that she worked. She's saying that this is behavior she was met with. And the lower court judge didn't seem to indicate that this wouldn't be a hostile work environment. He really relied on the fact that there's no way the department could have had knowledge. And I think that's a huge issue of material fact that's disputed because she's literally saying that she reported this to a captain of hers.
So what is the evidence in the record of retaliatory animus on the part of the department?
Sure, certainly. I have articulated a few of these instances on page 21 of the brief, but...
Page 21?
Page 21 of the brief, yes. So in addition to being called a whore and being ostracized and the room going quiet when she walked in and adverse assignments...
assignments plural. You gave us one instance and when she arrived at that prisoner, the other CO said, "Get out of here," and she never had contact with that prisoner. So are you saying there's more than one assignment?
There's the issue when she's pregnant and there's a combative inmate.
That's the one I just referenced.
Yep, and then there's also, my apologies, I'm just having a trouble locating it.
Do you think, is it your view that the violation of the tobacco policy was evidence of retaliation?
Yes, I think that the tobacco violation was misapplied, and I also think that
Even though she signed a last chance agreement?
even though she signed the last chance agreement, there's another last chance agreement that she refused to sign because it would have included a release of her claims, including this case. But to answer your earlier question about other instances of retaliation that are articulated, I think a huge piece of this is that she's on workers' comp for the stress that this caused her. She notifies the Department of Correction that her therapist has given her like 8 weeks in order to return to work. They immediately cut off her workers' compensation benefits. If her workers' compensation benefits get cut off, there's no further reason to surveil her. The department continues to surveil her, finds that she is smoking.
I mean, they'd already caught her smoking several times, once in violation of a last chance agreement. Having read DOC's brief, would you acknowledge that Chapter 27, Section 2, and its prohibition on smoking by certain employees of the department applies to your client as a correction officer who has care and custody of prisoners?
I would disagree with that statement because there's a disputed fact as to whether the change in the smoking policy would have applied to her or not.
Well, I'm asking about the statute. I mean, a policy of DOC can't supersede or contravene the statute. Would you agree with that?
I would agree with that.
Okay, so let's look at the statute. Is there anything in 27.2 that suggests that she is not covered, your client's not covered by the smoking prohibition?
I believe the change in the application of who it applies to is materialized.
How could DOC change who it applied to administratively if the statute says anyone who has care and custody of a prisoner?
And I would rely on the change in the DOC policy, while it may apply to her at work, it doesn't apply to her in her personal life, which is an issue of, again, disputed material fact. But what I would rather the court focus on is the fact that she's no longer collecting workers' comp. And the lower court, the record testimony is that she was surveilled because she was collecting workers' comp. And so if she's not collecting workers' comp anymore, why is she still being surveilled? I think that's a very important piece of retaliation because later on, the Department of Correction says, you're welcome to come back, please get fit.
She doesn't know that she's being surveilled until sometime after the termination has occurred. Is it retaliatory? I mean, does the action have to be known to the employee?
She does know that she's being surveilled because she was disciplined for it on multiple occasions. So,
no, but you're focusing now on the surveillance after her comp benefits were terminated.
Correct.
In order for that to be retaliatory, would she have to know that that particular episode of surveillance was occurring?
I don't think so, because ultimately what they say to her is you can't return to work. And it's because, and then they put her on knowledge that they had surveilled her. But again, had invited her to get fitted for uniforms and go to training and then terminate her the evening before she's supposed to return. I think these are continued acts of retaliation, and the lower court didn't properly address it.
Counsel, Judge Blake is...
I have two more questions for you.
Sure.
Can you address the fact that your notice of appeal was 1 day late?
Yes, I can. And my understanding is that because I had timely filed a motion for reconsideration, I had 21 days to file the notice of appeal after the motion for reconsideration was denied. And
Did you file a new notice of appeal after the motion for reconsideration was denied?
No, I didn't. I filed the motion for, I filed the notice of appeal on July 19th.
Right, the motion for reconsideration doesn't toll the notice of appeal.
My understanding was that the notice of appeal was filed prior so that it didn't, I wasn't required to refile a notice.
Should read the Eyster case, but I also have reason to believe that that rule may be changed in the foreseeable future. Speaking of cases, I don't understand your argument that Verdrager established new precedent. Can you help me with that?
Sure. So what Verdrager did was basically say, you know, if something happens on X date and then a termination happens on Y date, you don't just look at X date, you look at all of the things that happened in between X and Y, which is what I'm asking this court to do.
Isn't that what the judge below did?
Not at all. No. He looked at the date she reported the sexual harassment and found that it was not causally connected to her termination date. And what I believe he should have done if he had applied Verdrager was look at all of the steps that happened in between.
Did you argue Verdrager below?
Yes.
Because that was decided well before, right?
I did. I argued it in my motion for reconsideration, and it was denied.
Not in your principal motion.
I don't believe so.
Counsel, thank you very much.
Thank you.
We'll hear from DOC.
Good morning. May it please the court. I'm Judith Alamy for the Department of Correction. This appeal was not timely filed. The case was not timely filed in MCAD. Throughout the entire case, there has been running timelines, many of which were missed. She had from the clock started on December 2nd, 2014.
But why didn't you argue the case was too late?
I did.
Oh,
It was raised in the position statement in MCAD. It was also raised in the summary judgment. And again, in motion to for the opposition.
I'm talking about the appeal. I'm talking about the appeal.
I did not actually become aware of it until I checked on Friday when I got the email from this court. But yes, it is a day late. But the late filing in the MCAD has been raised since the position statement. She had 300 days from when the clock started running. If
That doesn't matter because she's not arguing the sexual harassment.
she's arguing the retaliation, and the retaliation she claims started running then.
What I'm struggling with in this case is Ms. Ferrie may have a difficult time at trial, but we're not at trial, we're at summary judgment. I understand that we don't have photographs of these pictures that said what they said according to Ms. Ferrie, but if we look at the case as we're required to, in the light most favorable to Ms. Ferrie, isn't there an issue of material fact as to whether or not after she filed the complaint in 2014, she was subjected to ongoing harassment by her peers, and then if in fact she made some reports to the captain that the department was at least implicitly on notice?
Ms. Ferrie contradicts herself as to what she reported to the captain. And also, there's a time issue in her reporting it to the captain. She does not remember when it was. She thinks it may have been in January 2016.
The judge was able to narrow it down. I mean, certainly narrow down the incident with Sergeant Lee.
Which was the same day as the incident with Captain Lafort.
Right. And he was able to narrow it down to, you know, early in that year, January, February, based on when she gave birth to her.
Which is beyond 300 days of the clock running on December 2nd, 2014. So she did not report any retaliation in the time period with the temporal proximity to her protected activity. But she also contradicts what she said to Captain Lafort. She's relying heavily now on a response to an interrogatory. But in those same interrogatories, or another set of interrogatories, she also said she never filed any reports of retaliation. So she contradicts herself with that. The one that she's relying upon, when you read it, she's also claiming she told Captain Lafort about the workers' comp eligibility being cut off, the surveillance, all of that. She's lumping into that interrogatory answer. None of it had happened when she met with Captain Lafort. Those all happened later.
So when the judge says that the department's motion to dismiss the sexual harassment claim is moot, you don't disagree with that because there wasn't a sexual harassment complaint, right?
It was not a sexual harassment complaint at that point.
It was a retaliation complaint.
For the, yes, for the protected activity of filing the sexual harassment complaint.
Following up on Judge Blake's earlier question, the judge said there was scant evidence, that was a quote, that DOC management knew about this. Scant is one of those wonderful, rich words that, and I'm actually looking at the dictionary definition here, barely sufficient or adequate, which says there is some evidence of the knowledge of all this going on. Why doesn't that raise a jury question?
That evidence is her own testimony, which is based upon, that evidence is her own testimony, based upon her conjecture, and she contradicts herself. And again, there is the time issue. Her complaint was never amended for the termination, which also has timing issues. It's more than 300 days beyond the second protected activity, and it's multiple years past the first protected activity. Never amended for that. The workers' compensation issues, which she relies upon heavily, were not properly before the lower court. Chapter 152 gives jurisdiction over all workers' compensation issues solely to the Department of Industrial Accidents. If she had an issue with her eligibility ending, that's where it belonged. If she had an issue with surveillance involving her workers' compensation, that's where it belonged. The surveillance did continue after the end of the eligibility because she had been granted partial eligibility by the Department of Industrial Accidents. She appealed that, seeking full disability, and the department had appealed it, seeking no responsibility. So there were two appeals going on together, combined, of her workers' compensation, even after her eligibility ended, which continued until October of 2022, at which point it settled.
Follow up, though, on Judge Milkey's correct definition of scant. It didn't say none.
It didn't say none.
Leading up to scant, the judge says, and this is where I'm struggling with what we're here for. We're here for summary judgment, that the evidence is sufficient to support an inference that the retaliatory acts were causally connected to Ferrie's report. She stated that in her answers to derogatories in her depo, that her colleagues' behavior changed. Second, a jury could reasonably infer the use of sexually charged derogatory remarks was related to her report. And then he drops a footnote to discuss the knowledge piece and says there's only the one incident related to LaForte and Lee, and that there are no facts which a jury could infer that assignment was causally connected to her protected conduct. So even the judge seems to be at odds with the evidence. Does that create an issue of material fact for summary judgment?
No.
Why?
Because there's just so much going on here. What she reported to Captain LaForte in her deposition completely contradicts and supports the judges that that's not related at all. Because in her deposition, she claims the only thing she reported to Captain LaForte was her confrontation with Sergeant Lee about the inmate. A job assignment well within her job duties, completely apart from any protected activity.
She have requested light duty as a pregnant CO?
She could have, and she did not.
And is that in the record?
It's in the record that she did not, yes. And it's in the record that the department cannot assume, because there's case law that the department cannot and the state police cannot just presume that a pregnant woman cannot do these tasks. The woman would have to come forward and request it.
Timing, because 2014 is when the sexual harassment took place. What if nothing had happened until 2019 and a captain said to her, you know, you're a problem, you've been a problem since 2014 when you reported so-and-so? Are those causally connected?
They're not temporally connected because it's beyond the statute of limitations.
Do you agree with the judge that there's not case law on what constitutes a hostile work environment? And do we need to reach that question?
No, we don't need to reach that question. There is case law that details bad acts that amount to making a workplace unbearable and hostile. And also goes into what doesn't. Occasional insults, graffiti, once or twice, does not rise to that level. Again, on that one, plaintiff contradicts herself. First, she claims in her complaint, and again today, that these posters are all over the place. But in her deposition, she says there were only 2 or 3, and they were in a printer tray, not on the walls.
2 or 3 is not enough.
2 or 3 is not enough, no. And she did not save them. She did not show them to anybody, not even her own husband, who himself never filed any complaints or reports of seeing any hostile acts toward his wife. No one else ever did.
Was he a CO in the same?
Yes, working the same shift until she returned from maternity leave. Then they were on different shifts.
So can we address Judge Sachs' question about what the DOC smoking policy was and what did it change to, and how does that interrelate to the statute?
The statute controls. The statute, which has been in effect for a very long period of time, has not changed, prohibits any correction officer, also applies to firefighters, law enforcement, and EMTs, I believe, cannot smoke because they receive benefits under the HART bills. When she applied for the job and did her application and her paperwork for accepting the job, she signed that she would comply with all rules and regulations of the Department of Correction.
Just want to clarify, you're conceding on behalf of your client that your client's policies are in violation of the statute?
No, we're not. No. Policy is not in violation of the statute. That is a misinterpretation by the plaintiff. The statute controls, statute forbids smoking. She agreed when she took the job, she signed paperwork that she would not smoke. The regulation, the policy upon which plaintiff is relying has 2 completely different sections. The section which the department depends upon has been unchanged for over a decade and states that all subject to the statute cannot smoke. The other provision has changed multiple times because there are people who are not, employees who are not subject to the statute. Correction officers are, teachers, nurses, secretaries are not. The section that she is relying upon applies to those people who are not subject to Chapter 27. Plaintiff is, at all times. That has never changed.
Why doesn't the agency efforts to settle the smoking issues the second time hurt your position? I understand the settlement was never executed, allegedly because of the release issues, but where the department expressed a willingness to keep her on board, notwithstanding the evidence of the second smoking violation, why isn't that some evidence that she was fired for reasons other than the smoking violation?
Very few employees have found smoking a second time. Those who have been terminated. The department invests considerable time and money in training these officers. It's not easy to find officers. It's not easy to find good officers. Her work was decent. So there was an effort made from her union. Her union was the one that reached out and said, can we settle this? To try to keep her employed. She did not cooperate with her own attorney at the union. She did not respond for months on end, delaying any action for months. And her reasons that are stated now don't actually apply either. You cannot waive claims under Chapter 125, and you cannot waive claims under MCAD. Neither of those could be waived. But had she pointed that out, her union attorney would have explained that to her, and the department could have adjusted that language as well. But that was never brought to the department's attention that that was her issue. Her union was
trouble finding in
representing
the
her.
record where there's evidence that it was her delay that prevented that second proposed settlement from either being accepted or definitively rejected.
In the record, it does discuss that the negotiations were ongoing, and that would delay it beyond the 7 days.
Is that necessarily attributable to her? I mean, negotiations are ongoing, could mean she'd made some proposal to DOC and DOC had never gotten back to her. How do we know that it should be laid at her feet?
It was, actually, in her deposition, she states that she did not get back to her union, that she admits that she was the delay. Any other
Counsel, you
questions?
have 9 seconds if you'd like to use it.
I think I'll rest on my brief. Thank you.
Thank you both very much. The case is submitted. In case you were wondering why I'm pausing, we have a new recording system that has to be reset each time. Our next and last case of the morning is 2022 P1210, PENNYMAC Loan Services versus Peter NATSIOS. Counsel.
Good morning, Your Honors. May it please the Court. Stephen Ryan on behalf of the plaintiff, Peter NATSIOS, trustee of the Kingsley Road Howell Realty Trust. And Your Honors, this appeal is really about the limits of a court's authority on summary judgment. In particular, it tests the ability of the court to draw inferences against the non-moving party, which is my client here, and to make determinations of credibility about witnesses prior to trial.
I know that the judge cited the Marcel affidavit. Is that necessary to the judge's conclusion? Isn't it enough based on the Adams case and looking at the 2009 mortgage property description and its incorporation by reference of the Marcel deed? Isn't that enough to conclude that the entire property, all 4 lots, were encumbered by that mortgage, without respect to what Ms. Marcel said in her affidavit 10 years later, or whether she executed a quick claim deed for the other 3 lots?
Well, I would like to get to that point about the quick claim deed, but I would answer the question first. No, Your Honor, we presented, first of all, we believe that the judge, in ruling the way that he did, engaged in drawing inferences, even on the construction that he was...
Let's assume that he did in his mind. Was that necessary to his decision? Would it be, on summary judgment, it's de novo, and we're just reviewing documents. We're not making any credibility determinations. Why isn't it enough to look at the 2009 mortgage and the property description attached to it and the Marcel deed to know exactly what this mortgage encumbers, regardless of what the parties did 10 years later?
Well, Your Honor, what I would say is that...
Looking at those documents, is there some issue of intent of the parties that needs to be settled?
Well, yes, Your Honor, I would say that the entire case was first brought as a case to quiet title based on reformation. And throughout the...
Well, that was one of the claims, but it was dismissed. And instead, the judge resolved it on what the defendant's brief, the plaintiff's brief characterizes as a mortgage as written basis.
And here's what I'll quote from the language from the judge that I think is the most critical to the ruling here.
I know that he said, what said in the Marcel affidavit, especially in the Marcel affidavit. I'm asking you to put that aside and say, without those references, could the judge's decision stand based solely on a reading of the documents from 2009 and earlier?
No, Your Honor, because we argue below and we argue in our appellate brief that even if one were to go solely to rules of construction, which we disagree that that's appropriate on summary judgment where there are factual issues, but if one were to go solely with issues of factual construction of the documents, the vesting deed refers to two separate plots of land, and that still creates an ambiguity with, and I'm looking in my brief now, Your Honor, I'll turn to the page so it's, so I make sure that I'm reflecting it accurately. But the vesting deed into the borrower Marcel, even if one were to go back to that vesting deed and treat it as controlling, which in addition, there's also a plan involved here, the Ken Burma plan.
So you're saying that the vesting deed could contribute to ambiguity because it says 224 and 225 for parcel 1, or 222 and 223 for parcel 2?
Absolutely, Your Honor, and the reason why is...
Then why would is it the Marcel deed or the 2009 mortgage property description? Okay, yes, the property description where the typo is of some sort. Why would it say lots 225 through 225 inclusive if the reference were intended to be to two neighboring lots, like 222, 223, or 224, 225? Why would you need to say inclusive?
So first, I believe that it's important to read the entire description, and that entire description begins with all that parcel, singular, of land in the township of Hull, and then it goes on to say, and designated as lot, see below, filed in Plat Book 1, page 18.
Lot is pluralized about 6 words later.
Correct, but that is why PENNYMAC filed this case asking for a mistake to be found, but it's their burden of proof to prove that when if I can step back just for a moment, and this is why we think that this was not well suited to summary judgment. This is a trial issue, because the question is, in 2009, when this mortgage was obtained, in between not the parties to this case, by Bank of America, which is no longer an owner of the mortgage, and by Therese Marcel, the question is whether there was a mutual mistake of those parties when they put this description into the mortgage. And they have to prove that, PENNYMAC has to prove that by clear and convincing evidence. It's not preponderance of the evidence, it's an elevated standard here, which is why we think that the judge should have allowed this to go past the summary judgment stage and to trial to ensure.
You said in your brief, pages 17 and 18, before you can rely, or we can rely on the Marcel deed description, the court must first find, and you later say by clear and convincing evidence, that the parties made the scrivener's error by mutual mistake and intended for the 2009 mortgage to cover all 4 lots. You haven't cited any authority for that in your brief, and I'm wondering if you have any.
I don't have a case. That's our argument, that the court, in this specific case, the court should have done that. And once there was this issue of ambiguity and this issue of fact, that's clearly created by the fact that Ms. Marcel acted one way in 2019 in deeding the 3 lots to another party, believing she owned the property. If you draw the inference in favor of my client, which the judge was required to in this case, she believed she owned those lots when she transferred them.
But we don't need to reach the party's intention or their actions even in 2019, 2021, if we can read the deed and the mortgage property description and the items referenced there to resolve what the parties at that time were referring to.
Well, for all intents and purposes, Your Honor, what the judge did is reform the deed. I mean, the judge issued an order stating that...
He interpreted, there are defects in deeds and misstatements all the time, but interpreting what the deed means is not reforming the deed necessarily, is it? And he dismissed the reformation.
So I'm saying for all intents and purposes, because what was done was an order was issued suitable for filing at the Registry of Deeds, clarifying what the exhibit to the mortgage said. Because as it stands, it's clearly, it doesn't make sense. But that's on the plaintiff to establish whether there was a mutual mistake, what the intention was. That none of that is on my client as a defendant in a case like that. And when there's a doubt, Your Honor, I would say that because summary judgment non-suits my client and takes us out of the case, it short-circuits our ability to present these issues that I'm presenting, that I'm trying to bring up now, that was improper at this stage, and it was beyond the bounds of his discretion on summary judgment. It should have been denied, and the case should have been allowed to proceed to trial, so these issues could have been sorted out. And then at trial, the judge could have completely ruled against my client based on the testimony, based on the evidence, but to short-circuit the process at summary judgment, especially where there was an entire pretrial proceeding leading up to it. So the case kind of went from being prepared for trial, and where witness lists were provided, to the plaintiff then determining to move for summary judgment on these issues of interpretation. But, Your Honor, I don't think, and I would just...
Can I just try to clarify something?
Yes, Your Honor.
It relates to an interchange that you and Judge Sachs had a while ago. How many different interpretations are there in terms of what was covered by the mortgage? Is it that it covered the one lot or all four, or are there intermediate interpretations that it covered two?
So there are the two polar extremes that it covers only the one lot, the mortgage, and then there's the other extreme that it covers all four lots, and then there's this intermediate interpretation, which my discussion with Justice Sachs, that it could be construed if to attempt to be referring to parcel 1 or parcel 2 in that vesting deed, because it's broken out in the vesting deed. There's no way to know unless we have a trial on this issue, because there's no proof from the plaintiff, and it's the plaintiff's burden as to what the intent actually was. It's not there. And one more point on the, if I might, I hope I've answered your question.
No, I'm just trying to tease out that your point, if I understand it, is, yeah, we can probably know from the face of the deed or the mortgage that there's an error here, but we don't know how to resolve that.
That's absolutely my point, Your Honor, and that's why a trial would be necessary. You can't resolve those issues on summary judgment because it deals with the intent of the parties at the time the mortgage was created. We have nothing from Bank of America in the way of an affidavit. We have conflicting actions from Ms. Marcel in what she did and then what she says in an affidavit. And of course, you can't cross-examine an affidavit. So that needs to be put to the test at trial. Her credibility is an issue at trial. So for all those reasons, we suggest that this court could vacate the order on summary judgment, and the result would be that the plaintiff would then have an opportunity to present its case at trial, and we would have the opportunity to present our case, and then the facts, the trial would sort out what the actual intent of the parties was, and when we have a clear understanding of what happened here. And I would point out one more piece of this with regards to rules of construction. The reference to a plan in the 2009 mortgage refers to the plan of land recorded with the registry, the Ken Burma plan. We have a case that we cite where it states that the reference to a plan can be deemed to control over other references.
Conflict, but what's the conflict?
Well, so it says here, the reference to a plan, it references lot 225 on the Ken Burma plan. That reference to that plan in lot 225, we would submit should control as a matter of construction.
Well, the plan shows hundreds of lots, including all four that are at issue here. How is that inconsistent with?
Well, we would simply say it's actually clearer if you refer to the plan and you're only referring to one specific lot. That 225 lot that's clearly delineated on the plan is all that's covered by the mortgage. Now, again, the other side strongly disagrees with that, but as a rule of construction, that is a rule that was not applied by the judge, but we submit that it should have been.
I want to address your argument that the judge's two rulings are internally contradictory and may cause chaos. Why can't the mortgagee, now that, let's assume that the judge got it right on the first issue, why can't the mortgagee now go out and do a proper foreclosure based on the correct property description? What's the chaos that results?
Well, because the judge has ruled that the deed, so here's the internal inconsistency from our perspective, Your Honor. The judge ruled that Exhibit A to the mortgage stands because it's proper and correct. But that Exhibit A refers on its face only to Lot 225. Now, there may be...
But it says as more fully described, or being more fully described in the Marcel deed, which talks about 4 lots.
And then, so to take that point, Your Honor, then the reason the foreclosure was deemed to be invalid was that exact same description was used in the foreclosure notices. And the judge said that's not sufficient notice for a proper foreclosure in the state of in the Commonwealth of Massachusetts because it's unclear what is being referred to.
Does it create some stalemate or problem in this case? Now that the judge has ruled, assuming we affirm that, and the judge said the foreclosure was invalid, so
Correct.
There would have to be another one, I assume. Why can't that foreclosure just use a more accurate and detailed property description that encompasses all 4 lots?
Well, I would say, Your Honor, that the judge got it right in the foreclosure, and we would hope that he would have done the same on the initial reformation count or the interpretation of the mortgage. But what I'm saying is, and perhaps I'm not articulating it clearly, but because that Exhibit A to the mortgage is still there, it's difficult in a foreclosure situation to look and see what you're actually purchasing because it's still confusing because it really should say exactly what it's covering, and it doesn't. Your Honor, before I use up my time, do you have further questions for me?
I have one further
Sure.
question, which is if the foreclosure was invalid, then who has the equity of redemption?
That's a question I think that would be resolved that I don't know the answer to right now.
Could it be anybody but Marcel?
Probably not. Although I don't.
Well, although she did a quitclaim deed for 3 of the lots.
3 of the lots. That's right. So
your client might have the equity for 3 lots.
That's right, Your Honor.
She might have the 4th.
That's right. That's what I would say. I don't want to take into my brother's time. My brother and I had agreed that there was a section of one of the exhibits that got cut off in the filing, and we had agreed to stipulate to supplement that for the court. I didn't rely on any of these.
Is that Exhibit L to the?
Was that what?
Was the statement, the exhibits to the original statement of undisputed material facts cut off in the middle of Exhibit L?
That may be
There
it.
were many exhibits after that.
Yeah,
that were not included. Some of them are elsewhere.
Some of them are elsewhere. We discussed that, and we'd be happy to submit a supplemental by stipulation if that would be helpful to the court.
That would be great.
Okay. Thank you, Your Honor. I didn't want to take your time to do that, so.
Thank you.
Thank you,
Counsel?
Your Honor.
Good morning, Your Honor. Your Honors, may it please the court. Just barely morning still. So, to respond to the issue raised by Justice Sachs regarding whether foreclosure could be done based on this judgment, it could be. A judgment of a Superior Court has the same effect as a deed. So once it's recorded, then to the extent that there would be questions in bidders' minds about the effect of the 2009 mortgage, that would resolve it. So that should not be a problem. I'd like to go over the case law some. In Ray Adams was the case.
Can we go back to one thing before you get into the case law? The trustee argues that the reference to the plan of Ken Burma somehow supports the trustee's position or creates a conflict. You also rely on the plan as supporting your position. I look at the plan and I see that it depicts all those lots and many more, and it doesn't really help narrow things down much. Who's right?
Your Honor, I believe you're correct on that, that the fact that the 2009 mortgage refers to the plan doesn't create any ambiguity or any problems. The 2009 mortgage refers to the deed, and or the Marcel deed, and that Marcel deed has a terrific legal description. It's got the metes and bounds. It's got all the lots that are included. So that's what determines what the mortgage encumbers. And it doesn't really matter that the deed has referenced, or sorry, that the mortgage has a reference to the plan.
It doesn't help you either?
I don't think it does because it's in the Marcel deed. I don't think it needs to be in the mortgage. The mortgage can just say, for a complete property description, refer to the deed. And in the cases, I haven't really seen that case where there's basically no property description and at all, and it refers to the deeds. But in addition to the bankruptcy court case, there are 4 SJC cases which are similar, where the property description doesn't include all of the lots. It just refers to a deed that adds lots or adds land. And one of them is the Foss v. Crisp case. That's the 1838 case, and that is cited in my brief. And in that case, the phrase was meaning and intending to convey, and then it referred to a vesting deed. And in our case, of course, it was being more fully described in, which I think is at least as effective as meaning and intending to convey, and even better in this case because it says, being more fully described says, this is where you look for the description, and that's where it is. So in the Foss v. Crisp case, the 1838 SJC case, the deed's description only had 6 of 7 parcels. And by referring to a deed, the SJC held that it added in the 7th parcel. And this is the quote. It's not in my brief, so I'm just going to, with the court's permission, just quote a sentence here. He omitted the particular description of the metes and bounds of the Fuller lot, but he referred to the records for the certainty of the description of that part of the granted premises, and the reference is to be considered as included in the conveyance. So that's what we have here. It's the reference to the deed that added the 3 lots. So that SJC case is on point. In Ray Adams, it's just a very similar case. The mortgage described lot 32 and it referred to a deed that added lots 30 and 31. Coogan v. Mills, also discussed in the brief, that also applied to that rule. The reference to the recorded deed only had one of the lots, and the reference deeds added the rest of the lots.
So in other words, that the deed or the mortgage at issue refers to only one lot, and the deeds that it incorporates refer to multiple lots, does not create an inconsistency.
Yes, Your Honor.
But were those cases on summary judgment?
I don't know if they were on, in Ray Adams was on summary judgment. The SJC cases, I don't know if they were on summary judgment, but they were based on the deeds. They're based on the title documents. They didn't talk about any oral evidence, parole testimony. It was just based on the title documents. So that's something that could be decided on summary judgment.
But getting back to my earlier question, you can look at the face of the documents and see that there's a mistake. But can you resolve that mistake where there are different permutations of what could have been intended?
Yes, Your Honor, you can. By looking first looking at the deed, which is referenced, the Marcel deed, it's got the complete description, and the mortgage just says, more fully described, this is where you go to get the full description. And so you look at that, and then you look at all these cases, the 4 SJC cases and the bankruptcy court case in Ray Adams, and they are instructive about what's done. If there's a question and ambiguity in the description of the deed or the mortgage, then you look to the reference deed to resolve that and to figure it out. And so that's what needs to be done here. And so and there's also the REBA title standard 27, which I include in the addendum that says the same thing. And ambiguity in the property description can be resolved by reference to a deed. And that title standard is based on Abbott v. Frazier, which is cited in the comment, 240 Mass. 586, 1922. And in that case, the deed incorporated 3 other deeds into the property description, and which ended up adding a strip of land. And the phrases in those 3 deeds were, one was meaning and intending to convey, and the other 2 was being the land deeded to me by. So there's some deed references that have for Title C deed book page, and that's not as good as meaning and intending, but in this case, being the same property described, or being more fully described, that really tells you this is where you go to get the description. Another case is Ide v. Bowen, 342 Mass. 22, 1961 case, and that's in the comment to REBA Title Standard 27. Sorry, Abbott v. Frazier I cited in the case, but Ide v. Bowen is one that's in the comment to Title Standard 27. And it had being all the properties, and the deed said being all the properties in Seekonk, Massachusetts belonging to the estate of late John P. Barney, and that reference to the estate of John P. Barney added in the other property that was in his estate. So very similar to what's here. We've got 4 SJC cases.
So you said Foss, Coogan, Everett, and the 4th one was somebody versus Bowen?
Ide, IDE v. Bowen.
Ide, okay, thank you.
342 Mass. 22. And there really aren't any cases on the other side. In Ray Benton, it was a completely different legal description from the street address on the property. So that's why the bankruptcy court struck down that mortgage. So very different.
I have to assume that things like this happen with typos. So if this had happened shortly after, what would the ordinary course be to correct it?
Or
This litigation didn't happen.
Well,
Then you realized, ooh, it should have been 222.
usually at a closing, one of the documents signed is a document where the mortgagor agrees to correct mistakes in the closing documents. And so
Is there a time period in which?
I think that might have a year for getting it done. But here it was back in 2009, and now it's 2020, and the mortgage was assigned from Bank of America to PENNYMAC.
A lot of people missed it along the way.
Yes, a lot of people missed it along the way. A lot of people apparently don't really read mortgages.
Can't understand why.
So hypothetically, if we were to affirm, you agree that the judge said that foreclosure was invalid, so presumably there's got to be another foreclosure?
I'm sorry, did you ask if the foreclosure would need to be redone?
Yes.
Yes, it would need to be redone, definitely.
Who needs to be foreclosed upon?
I think Your Honor had an excellent point, that it would be the trust as to those 3 parcels, because Therese Marcel did convey them.
And Marcel has
And Marcel as to the other parcel. I think that's correct.
Do we need to rely on the fact that the registry, as the judge pointed out in his decision, associated the 2009 mortgage with 173 Kingsley Road? And do we need to rely on the parcel ID corresponding to a 7,200 square foot lot in the assessor's records, which would necessarily be all 4 lots?
I don't think we need to rely on those facts, but they certainly are facts that could be relied on. And the assessor parcel number is in the mortgage, both at page 2 and Exhibit A, and the street address is too. So I think those are significant facts, but not essential to the decision. All right, thank you.
Thank you both very much. The case is submitted, and that concludes our sitting this morning. My thanks to the court officers and the clerks for their assistance in allowing this hearing to go forward. We are adjourned.
All rise, please.
what keeps me from